heard the words T's and C's apply, or actually seen the writing which is strategically placed below and made small so that nobody can read it? If you have, then I'm pretty sure you've wondered what those terms and conditions actually are. Well, guess what? All contracts are made up of terms and conditions. And in this video, I'll be explaining what those terms and conditions actually mean. So without wasting any time, let's get to it. Hello and welcome to Talking Small to the Dando Man. I'm the Dando Man, the best there is, there was, and there is to come. Thank you once again for joining me for today's edition of Talking Small to the Dando Man. This channel will equip you with the tools, skills, and information you need in order to start and grow your business. So if you're interested in content like that, then consider subscribing and hitting the notification bell so that you are able to receive these videos. We are at 80 something subscribers, and let's take it to 100. Hashtag road to 100. And yeah, let's keep on pushing. Tell your friends about this channel and anybody you know which would be interested in content like this. So basically today we'll be talking about the terms in a contract. Now, as I said earlier on, that all contracts are made up of terms and conditions. So there are different terms which exist in a contract, and they are each placed in different categories, and they are placed in those categories according to their characteristics. So today I'll be taking you through each category and what terms exist in those categories. Now, the first category of terms which exist are what we call Essentialia, Naturalia, and incidentalia. Let me say that right. Naturalia, Essentialia, and incidentalia. Naturalia, Essentialia, Essentialia. Okay, never mind. Okay, so these terms exist in this category. The first one is Essentialia. Basically, Essentialia terms are terms in a contract which the law requires to be there in order to place that contract into a certain category. So for example, in a contract of lease, the Essentialia terms are that you have to let somebody else have use of the property which you are leasing to them. So that's the Essentialia term of the contract, which places that contract in the category of a contract of lease. So the next term, which is part of the category, is Naturalia. Basically, those terms are terms which are automatically there by the operation of the law. They don't have to be spoken about or written. They are there just because the law requires it to be there for those certain types of contracts. So for example, in a contract of lease, there is a Naturalia term which is called the tacit hypothec. This is basically a remedy for the landlord just in case the tenant is unable to pay the rent or is in arrears. It's basically there for them to, it serves as a form of security whereby they can attach the goods of the tenant and basically sell it for the amount of money which is needed for rent, and so on and so forth. So basically, this Naturalia term does not have to be included, does not have to be expressed in any way. It just exists there by operation of law because of the contract of lease. That's what a Naturalia term actually means. So basically, the third term which exists in this category is what we call the incidentalia. Basically, the incidentalia are terms or those additional terms which are included in the contract by the contracting party so as to satisfy this mutual arrangement. For example, if we enter into a contract of sale, you want to sell me your car and we agree, and then we add the terms that the car will be delivered on a certain date, at a certain place, at a certain time. Basically, those are what we call incidentalia terms. So basically, the second category of terms are essential and non-essential terms. Basically, essential terms are those terms which are of great importance or are the essence of the contract. So if someone breaches those essential terms, the aggrieved party can claim damages or even cancel the whole contract. So for example, an essential term in the contract of sale for a car perhaps is that the car has to be in good and proper working condition, and so then we You come, you arrive with the car is basically damaged, it's not in the condition which was expressed in the contract, and so then I can basically maybe claim damages or even cancel the whole contract. I'll probably cancel the contract, but okay, yeah, those are essential terms. So non-essential terms are terms which are also in the contract but are not of great importance. So if a party breaches those terms, those non-essential terms, the breach does not necessitate a cancellation of the contract. However, the aggrieved party may claim damages. For example, if I needed the car today at 12, then so that I can start working, and then you bring it at 2 o'clock, that's a non-essential term, but because I needed to work there, I can claim damages for basically the time or the money which I was supposed to earn within that time. That's an example of a non-essential term. Then the third category which exists are what we call express and implied terms. Express terms are basically terms which are expressed, basically terms which are stated either verbally or written by the contracting parties. So for example, we both express in the contract, or one of the parties express that one of the terms of the contract is that the car has to be at a certain place at a certain time. We have expressed that desire or that need. Or in the contract of lease, we have expressed that this is the house which we want to let to you. This is the purchase price of the car. This is the amount of rent that you as a tenant have to pay. Basically, implied terms are those terms which are not expressly stated in a contract. They become part of the contract automatically by operation of law, just like Naturalia terms, or because of the circumstances pertaining to the contract, or the terms are implied by the conduct of a contracting party. So for example, maybe you placed in an advert that your car is in a good and working condition and all that, and then I made you an offer and so on and so forth, and in our contract it's not really expressed that the car has to be in good and working condition, but because of your conduct, because of that advert that you made or whatever, and the promise that you made that is good and proper working condition, basically that is an implied term, and that is what I would expect from the contract. So the fourth category of terms which exists are conditions. Conditions are terms in the contract which make the operation of the contract dependent or contingent on an occurrence or non-occurrence of an uncertain future event. So there are two types of conditions. The first one is what we call the suspensive condition. A suspensive condition is basically a term in a contract which postpones the operation of the contract until the future uncertain events actually happen. So for example, if I promise to buy my sister Kwele a car if she passes her matric with an 80% aggregate. This is an example, I'm not promising you anything, Kwele. So if she passes her matric but with an A aggregate, with an 80% aggregate, then I would have to buy her that car. However, if she doesn't, then that contract will not basically exist. So that's what a suspensive condition actually means. So then the second type of condition which is there is, or are, what we call dilutive conditions. Resolutive conditions are those terms which give effect to the consequences of the contract unless an uncertain future event occurs. In that case, then the contract will have to be cancelled. So for example, if I buy my sister a car and then give it to her and tell her that if she fails her exams, so she'd have to give back the car. So then if she does actually fail her exam, then the contract will be cancelled because of the resolutive condition which we agreed upon. However, if she passes, then she gets to keep her car. So humble seed. Basically, the final category of terms are what we call guarantees. Basically, a guarantee is when one of the contracting parties undertakes to take responsibility for a representation that they've made in relation or in regard to the terms of the contract. For example, if I sell you a phone and tell you that it is waterproof, that no water can damage it, then I've made a guarantee through this representation. And if the phone gets damaged by water and so on and so forth, then you have the opportunity to claim damages or even cancel the contract. If you found value from this video, please do like and share it and comment on the comment section below. Tell us what you think. Tell us which topics we should cover on future videos. Thank you very much for joining me. Please do like our Facebook page and follow it as well. Follow our Instagram page as well, Talking Smart and Talking Smart to the Dando Man respectively. And go check out our podcast, Talking Smart to the Dando Man, available on Anchor, Spotify, Google Podcasts, Breaker, or any other platforms which you get your podcasts from. The link will be down in the description box below. Thank you very much for joining me. This is it from me, the Dando Man. The best there is, there was, and there is to come. Thank you very much. Remember, you'll never turn your dreams into a reality while you're still asleep.